Hello, everyone. This evening's session is being sponsored by the American Bank and Trust of Quad Cities. My name is Mary Heil, and I'll be the coordinator for this evening. Tonight, Mary Ann will be talking about guardianship versus powers of attorney. Our presenters this evening will be Mary Ann Ellert, president and founder of Protected Tomorrows, and Kirsten Izat from the Estate Planning Law Group. Before we begin, there are a few housekeeping items. We ask that everyone keep your video and microphones off for the duration of the presentation. We do lock access to this presentation 5 minutes in, and you will not be able to reconnect if you're disconnected. The class is being recorded, and you will be able to view it once it has been placed on the ARC's website. I'd like to bring your attention to the bottom of your Zoom window. If you have questions during the class, click on the chat balloon and enter your questions in the dialog box that's in the lower right-hand corner of the screen and press enter. We'll answer as many as possible at the end of the presentation. And now I'd like to introduce Mary Ann Ellert.
Hello, everyone, and happy to see you. I actually don't see all of your faces, so I'm going to try to push around a little bit and see everybody. But before we get started, I wanted to see, is Trista Foster on, Mary? Yeah. No? Okay. So in a little bit at the end, we will see if she's there. She is with the American Bank and Trust. I wanted to give her some time to introduce the bank. But for now, we'll get started. So I am very, very excited tonight that we have a guest. And it's going to be, oops, I'm always pushing things too soon. And Kirsten Izat is an attorney. I'm going to let her take a minute and just introduce herself, and then we'll get started. So Kirsten.
Oh, hi there. Good evening. It's nice to be here. My name's Kirsten Izat. I'm an attorney with the Estate Planning Law Group, and I focus on estate planning, setting up special needs trusts, guardianship, creating powers of attorney, and so forth. Most of my practice is dedicated to working with families who have children with special needs.
And so Kirsten has been gracious enough to speak tonight because I am not an attorney. I see lots of families, talk to families a lot, and I get a lot of questions about a couple of topics that could be confusing. But some of you are new, so I thought I would take a minute and just introduce myself. I am a financial professional, but more importantly, I am a sister, a daughter, and a mother of someone with special needs. So this is my sister, Marcia, had cerebral palsy. Many of you already know all about her. She's why I do what I do. Here she is. This middle picture was at my parents' 50th wedding anniversary, and it was so fun. She saved she worked at the workshop at Clearbrook, and she crushed cans, and I think she made like $12 a month or something, but she saved the money because she paid for the flowers for the party, and it wasn't cheap. So she kept saying to me, do I have enough? Do I have enough? But she just had a full life. She lived at Clearbrook for 9 years, and then at the age of 39, she had a seizure in her sleep. She couldn't turn over, and she had suffocated. It took me a while to start to do this again after that occurred, but I still hear her voice telling me keep going. 31 years later, I still hear her voice telling me to keep going, and here we are. So I do this out of my love for her. I have a son with special needs. Both of my parents became disabled as they got older, and so I've learned most of what I know from my family and from you all who are asking us questions. And it's why I learned about one of the things that's really important to you is to get something done, right? Mm-hmm. Our lives are so full. Every day we go to work or we work from home. The last 2 years have totally changed the way we operate, right? We've had to adjust to our child being in group homes or being home or being homeschooled. Our kids were impacted probably more than a lot of other children, even though they all were impacted. And so our lives are full. And then people like Kirsten and I come and tell you, you need to get legal work done. You need to do guardianship. You need to save money differently. You need to do all these things. And so I've learned one step at a time is a really important thing to keep track of, right? It's a really important item. And so we're talking about one of the items in number 3 today is the legal work that you have to do. And one of them being thinking about guardianship. The other thing that I put in context is our team. And our team is in the middle. It's our family members. So my son would be the PWD, person with a disability. The family is his brothers and his aunts and uncles and parents and grandparents and everybody around him. And then we've got the whole people that we all count on, right? So I guarantee you that if something happens to me, my son has 2 brothers, but they won't know which direction to go, right? And so it's going to be really important that I'm setting up trustees and I'm setting up guardians and I'm setting up all these people so that whoever gets the job when I'm gone are going to be there. And so knowing who the guardianship attorney is and knowing who advocates are and knowing his medical needs are all really important. And they're important to talk to those people. It's important to document the team, as we talked about in our last class. Lots of information on our website for those of you who haven't looked at it. We're continuing to make major changes and expansions of it in the next year. All right. So here we are, and we have, it said guardianship versus power of attorney, but I thought it was a good time to start bringing up this supported decision making as well. Mm-hmm. So with that, we're going to talk about powers of attorney in kind of the order of how things occur, right? So powers of attorney to supported decision making in the guardianship decisions. So I know very little about these things. I brought in the expert today who can help us. And so let's get started. I'm going to ask the question. Kirsten's going to answer the question. And what I'm hoping you'll do is type if you have specific questions to your situation or generally, if you could take your question and put it into the chat box, and Mary will look at that and let us know. So we're going to be really interactive tonight. So if you have a specific question, you can ask that. Okay. All right. So, what is a power of attorney? And are there different kinds?
Yes, there are. So a power of attorney is where an individual designates an agent to act on their behalf. So the principal retains all of their ability to make decisions, but in some cases, if they might become incapacitated, they want to name somebody to be able to make decisions, to conduct business on their behalf, to deal with bank accounts, or to make medical decisions. There's 2 kinds of powers of attorney. There's what we call a healthcare power of attorney, which is very important. The healthcare agent has the ability to make medical decisions on behalf of the individual who appoints them. And then a property or a financial power of attorney is where the individual appoints somebody to manage financial affairs. The important thing to understand about the powers of attorney is the person designating the agent still retains their ability to make decisions. They're not giving anything up. They're just empowering somebody to make decisions on their behalf when needed. So.
Okay. I had dogs barking in my background, so I muted myself for a moment. Thank you. All right. So we understand a little bit about that. So now when we look at what's the next thing that we need to worry about is who should get one? Who needs a power of attorney? When should you get? If you need a power of attorney, when do you need to get one? Oh, now you are muted too, Mary. You're muted too. We're having a little technical difficulties here.
I've asked Kirsten to unmute herself.
There we go.
Okay, good.
Okay, is that all working? Okay,
yes, now we're back to normal.
All right, let's go back to the question.
Who needs a power of attorney, and when should they get a power of attorney?
So all adults who have the ability to make decisions, once they turn 18, pretty much everybody needs a power of attorney, because all of us can go from being able to make decisions to not being able to make decisions. So children do not need to appoint powers of attorney, and they don't have legal capacity to do that because they're under age 18. So anyone who's an adult, at least age 18, and has somebody that they want to name, it's important for them to name an agent under their power of attorney.
So what I find sometimes is we have young adults who are 18, 19, 20, now no disabilities, but are young adult children. Should they be getting a power of attorney for themselves?
It depends on if they have decisional capacity. So they have to be able to kind of sit down, understand what they're doing. appoint an agent. When somebody turns 18, it's hard for the parent to make decisions on their behalf. Sometimes the parents are kind of cut off from decision making. All of a sudden you find out that your child, is signing documents, you're not sure what's going on. So in those cases, if the child retains their decisional capacity, has that ability, they really should name an agent in that situation to help them. But that's the key issue. Do they have capacity to do that? Do they understand what they're doing? But if they're able to name an agent, then that would certainly be appropriate.
So if we have children who are going off to college, they probably should have documents prepared.
Yes, both of my young adult children on their 18th birthdays, they came into my office and they signed powers of attorney that were prepared and so forth. So, and I try to educate our clients about that. And so a lot of them, before their adult children go off to college, they're in here the summer before and they're signing those documents. It's kind of irrelevant, if they have a disability or not, any young adult should, as long as they have that capacity to make that decision.
Got it. So where do we have powers of attorney prepared? How do we get those? Where do you go?
Well, there's form document powers of attorney. If you want legal advice, you're going to need to work with an attorney. There's the form documents set forth very specific powers, but it's also possible to customize the powers of attorney to give broad powers. It's also possible to narrow the powers. And so that involves legal advice, but it is possible. There are statutory form documents out there. And some people will prepare those on their own, but the people we work with, of course, they are working with us as a law office or work with other attorneys in order to have legal, advice so that they're properly prepared.
The other thing I find is sometimes people will come into my office, a new person we're working with and we're talking to, and they bring us their documents and their powers of attorney. They say, well, we do have powers of attorney, and they were done 15, 20 years ago, right? And we would look at them and they're like, oh, is that who I put? They're surprised who they put as an agent. The other thing we have is sometimes a client will come in and they are talking up to us about their parents. And they want to talk to us about their parents' money, and we really can't unless they have power of attorney or trustee. But secondly, sometimes we're trying to help them with things for their parents, but the parents' documents are so old, the financial institution doesn't want to honor them. At that point, the parent doesn't have capacity. So we always ask people every 5 years, look at them again, look at your documents, make sure that if you need to make some changes, especially in the powers of attorney, that you talk to your attorney.
That is a problem with the financial or the property power of attorney. Sometimes banks are very hesitant to accept those documents if they are old documents. And we run into a situation where, we see if we can do a certification of the power of attorney, we put a little pressure on them. But you're right, having refreshed documents, that's where the financial institutions are going to be more comfortable accepting those documents.
Right. Thank you. So we just talked about that. They need to be up. You need to look at them regularly. You need to see who you picked. Sometimes you picked Uncle John to be your power of attorney for finance or something, and you find out that Uncle John wasn't so good with money. So keeping up to date with who you picked is important. So now we got this new thing that's coming about, this supported decision making. What is it, and when might it be a good choice?
So this is a new act. So it's the Supported Decision-Making Agreement Act. It was signed, I think, at the end of August 2021. And in February 27th is when this is going to be enacted and when this is going to be a formal option. So this is an option that's available to individuals who have decisional capacity. They have the ability to make decisions. However, they need support with regard to making those decisions. So for example, oftentimes it's very difficult to access information regarding, health insurance and benefits and decisions within an academic environment in a school situation. And so through this new statute, this new law, an individual with an intellectual or a developmental disability can name what the statute refers to as a supporter. And the supporter does not make decisions for the individual. Instead, the supporter helps the individual access information. They can also schedule appointments, follow up, but the individual always retains that ability to make decisions. So that's the big difference between this and the power of attorney. So this is really an exciting additional option that I think is going to make a big difference with certain families and individuals. It really encourages independence, appropriate decision making. And I think as people become used to this concept and they become familiar with the terms, I think it's going to be well accepted, although it might take a little while before people get used to this language, because it's definitely a new concept.
I'm still a little confused.
Mm-hmm.
So if I have a power of attorney,
Mm-hmm.
I am giving the rights to someone else to make decisions, but I'm not giving my rights up, right?
Mm-hmm. Correct.
So they have authority to do something. Is it only that person still has the rights, but the other person can't do it for them? They're only there to support them? Is that the difference?
Yes, the other person, the supporter, cannot make the decisions. Okay, so the individual who's designated needs to be aware of the limits of their role. The other thing is, this document, at least from what I can tell, it's not something that you present to a bank. It's not something that you're going to present to a medical provider necessarily. So if you're relying on this, the individual, the person with a disability, is going to have to sign releases. So if you look on the Guardianship Advocacy Commission website, there's various releases related to school matters, related to medical information, a HIPAA release. So what I envision happening is that when this arrangement or this agreement is made, that there would be a series of these releases that go with it, depending on how that individual wants support. Do they want support primarily with, accessing their health insurance and so forth, or in finding work? So it might be very specific to that situation.
Wow. So there'll be more coming out about this too over time, I'm going to guess. Yeah, because it's so new. It isn't even active yet.
Yeah, and it seems to be pretty flexible in the sense that you could name more than one supporter who could serve in this role. I think it's kind of formalizing arrangements that are already happening out there. I think this kind of arrangement naturally happens, but it's formalizing it in such a way that it's documented. If there was concern about, if somebody was taking advantage of the person with a disability, there's like a court remedy and so forth. So it'll be interesting to see how it develops over time.
And there is an actual agreement called the Supported Decision-Making Agreement.
It's an agreement. So I kind of think of it, I don't know if I'd call it a contract, but it's an agreement between parties. And so the supporter has to accept this role. So it's not something where you just sign and appoint somebody. Like, they have to accept, and then, the duties are delineated in terms of what that individual wants. So if you look at one of the sample agreements, there could be assistance with managing financial affairs, applying for public benefits, helping me find work, helping me with school, and so forth. So it's really meant to encourage independence and autonomy in decision-making. Yeah. I don't think it's a substitute, though, for really a power of attorney, right? Because if somebody becomes incapacitated, right, you're going to have that role. This doesn't give that individual the ability to make decisions when necessary.
So do you think a person who had a supported decision-making agreement would also have a power of attorney?
I think so. Yes.
Yeah. So that they became, so their power of attorney wouldn't be immediate, but it would be when I become incapacitated, somebody steps in. Yeah.
Yes.
Yeah. I just realized that would be.
Yeah. It's going to be all of more documents.
So we talked about, so when we talk about this now, we're going to go into a guardianship. So we kind of understand powers of attorney and supported decision-making. So now let's go into guardianship, and what's the real big difference there?
The big difference with guardianship is that when somebody does not have the ability to make decisions, they can't manage their personal affairs, they can't go to the doctor and make a decision, they can't manage their finances, that's where we get a court order adjudicating that person to be a disabled or incapacitated person. Once that determination is made, then a guardian is appointed to make decisions for them. So it removes decision-making authority from the individual and gives it to another person. And fortunately, under Illinois law, there's a duty to maximize the independence of the ward. So there's always a duty to consult and consider their opinion and so forth. But at the end of the day, the guardian has a lot of authority.
Okay. So if I determine, based upon that conversation, that I really should become guardian, when should I file?
So you're going to file right when your child turns 18. Okay. Now, you can petition to become a guardian of somebody at any age, but if your child has a developmental disability or intellectual disability and guardianship's appropriate, you would do that at 18. At 18, your child is emancipated. They're a legal adult. And so the process of going to guardianship court and petitioning is the process really of removing that adult status from them and taking them back to the position of a minor child. So it is a serious thing, but it's also, when it's appropriate, it's completely the right solution, right? So you want to make sure it's appropriate. You know, I think there's a lot more awareness about guardianship, you know, with the Britney Spears situation. Everybody's watching that. It's called conservatorship in California. So when it's appropriate, it protects the individual. There's a duty to maximize their independence. It really gives the guardian the ability to do what's necessary to protect a vulnerable individual. And sometimes we don't know, do we need guardianship or not? And so I'm always suggesting, you know, let's talk to the doctor. What does the doctor say about this? That's where we're going to be looking. What do they think is appropriate?
Yeah. So what are the different types of guardianship?
So the basic type that pretty much everybody would need when the situation is appropriate is guardianship of the person. So there's guardianship of the person, there's guardianship of the estate. So when a guardian of the person is appointed, that means that the guardian has the ability to make medical decisions, to decide where the ward is going to live, who their friends are going to be. They control all of those personal decisions that affect the individual's well-being and care and so forth. But of course, medical, I think, is the most important. When the individual with a disability has an estate, when they have money, when they have assets for whatever reason, that's where we have to open up the estate. So in many cases, we really don't need to open an estate because the person with a disability only has Social Security. The parent is appointed the representative payee. There's no other assets. Sometimes we can get away with, you know, where we really don't need a guardian of the estate. But sometimes individuals have inheritances that they received when they were a minor. Sometimes they have property. Sometimes they have a work record where they had savings and became disabled later in life. So those are scenarios where we are going to open an estate, and then the guardian of the estate will manage the finances, largely pursuant to court order. There's a lot of authority, but most of their authority is exercised pursuant to a court order. It's very highly supervised.
Yeah. What's a plenary guardianship? I hear that term.
So plenary means full. So it means a full, complete, permanent guardianship. There's a finding and adjudication of incapacity or disability. All right. As opposed to, you haven't asked about limited guardianship, but with limited, there isn't the same finding of disability being made. So that's the big difference. Plenary guardianship is much more common than the limited guardianship.
And what would a limited, if you said, sometimes people say, well, I want my child to be able to vote or drive, or does that come into limited guardianship, or what would that else would that?
Well, in Illinois, even if there's a plenary guardianship, you retain the right to vote. So Illinois is, I don't know if the right word is generous, but Illinois, you have broad rights to vote. That is not the case in all other states. I think driving, you know, that ability to retain your driver's license is probably, you know, for young adults, at least, the most likely scenario where you might want to consider the limited guardianship, because there's no finding of incapacity or disability. That's the trigger that can cause problems with the driver's license. You could reserve the right to drive potentially, but That's where I would see that issue come up. Otherwise, plenary, it's hard to delineate. Well, you can do this, but you can't do that, and going back and forth. So it's pretty uncommon. Sometimes a power of attorney is in place, but it doesn't have a power that we need. And so instead, we have to go to court to get a limited power to do X, Y, and Z, because we know the person is incapacitated. So we have to go to court. So that's another scenario where limited guardianship might be appropriate.
Yeah. There was a little while when the ABLE account first came about in Illinois that they would not let the parent open an ABLE unless the parent if they were guardians, they had to be guardianship of the estate. They've eliminated that now.
Yeah, it's just guarding the person now, but that's right. They were strict on that, and
yeah,
I've seen people with just the person open it, which is the right result.
Yeah. So, where do I do this?
So, guardianship petitions are filed in the county court where the potential ward resides. So, usually that's going to be in the home of the parents. But that's the court that has jurisdiction. Now, interestingly enough, if you have a young adult child who is placed through their school district out of state, the court here in Illinois will still have jurisdiction over them. So I have one coming up where the ward is residing in Kansas, outside of Wichita, Kansas. I've done them where they're in Connecticut at a residential school. So those are kind of exceptions, but the idea, at least in Illinois, is that they're under the, supervision of the Illinois school district. They're just placed out of state, and the intent is for them to come back. So that's how I've seen the courts handle it.
Yeah, we have a client who, she is in Ohio, she's from Ohio, and that guardianship is in Ohio, but she's going to a special needs school in Wisconsin. But now school's almost over, and we're thinking she's going to finalize her residential placement in Wisconsin. So we're going to have to move.
Then you're going to have to move the
guardianship, right? A lot of parents don't realize that's necessary.
Yeah, in Wisconsin, I think that's one where you're going to just have to open a new one. Some states you can transfer the guardianship. In others, you just shut it down and you open a new one. It's pretty much the same amount of effort, but it depends on a statute out there. And
and some states like Wisconsin, if you're going to be getting Medicaid in Wisconsin and your guardian, you have to have the guardianship in Wisconsin.
Oh, okay. Yeah. So guardianship is governed by state law. It's not federal law. And so when you go from state to state, you're probably going to have to open up a new guardianship if you move. So.
Is it also different county to county?
No, it slightly. Local courts all have their own rules, but all courts in Illinois follow the same guardianship statute. So there are slight differences with regard to how often are they required to report to the court. So some courts require yearly reports, others every 3 years. The Illinois statute requires at least every 3 years. So no court is going to go beyond that. But some courts, are stricter, and, Cook County every single, year, no matter what. I think DuPage is just switching to every 2 years, so it depends on the local, county, but they all follow the same statute.
Kirsten, we had a question on how do you move from county to county?
Well, right. If the family moves from one county to another county, and the judge kind of notices that, usually they're pretty happy. They kind of say, well, you're going to need to transfer this to a different county because that court doesn't really retain jurisdiction. So if there's property in a particular county, if the guardian is in a county, or if the ward is in the county, the court can retain jurisdiction. But if all of those things move to a new county, then you may have to do a transfer from one county to the other. So
if the child lives in a group home in Cook and the parents move to Lake County, it's where the child lives.
It's where the child is. It's where the child is.
So they wouldn't have to move it if the child stayed.
That's where, once they're placed in a group home, that's going to be their permanent resident. That's not temporary, residence, like
right.
a young adult, that's a permanent. So that's where
Right.
you want the guardianship to be.
Okay. So what's the cost to do this?
So when it comes to guardianship, there's filing costs related to the court. So that varies county to county. That can range from like $150 to $250, the filing cost. Then there's also a fee for the process server, which can range from $50 to $100. And then in addition to that, there's legal costs. So most guardianship attorneys that I know, they'll charge a basic fixed fee for a guardianship that's not contested, where there's not complicated assets, but that's going to range. I mean, you probably want to budget a couple $1,000s in some to get it taken care of. Complicated cases, usually the attorneys are going to charge hourly because, it's a court proceeding and the scope of work can vary.
And sometimes those guardianships in divorce and things like that can get messy in the court.
Yes.
Or if someone else is coming to the table and saying, well, wait a minute, I should have a say.
Yes,
So,
whenever
yeah.
it could be litigation. I mean, most guardianships for the young adults, they're not contested. There's no objection. Everybody's in agreement. That's a pretty modest, fee,
Right.
but anything can change to litigation. If somebody contested, if parents are divorced, if one wants to be the guardian and doesn't want the other one on there, I mean, that could turn into full-blown litigation. And what happens in those cases is attorneys charge hourly. Fortunately, that doesn't happen too much. There's a big disincentive to doing that because it can become so costly, and try to come up with an agreement. So that result is certainly preferred.
Isn't there also the chance at which the judge isn't sure, and so he will appoint a guardian ad litem?
Yes.
What's that about?
So a guardian ad litem is a third party attorney who is brought into a case to be the eyes and ears of the judge. So they're looking out really for the best interest of the respondent, the potential ward, the individual with a disability. And so what they will do is they will interview everyone, and then they will prepare a report that will be submitted to the court, and then they will make a recommendation. Fortunately, if the case is not contested, then the judge will usually waive the appointment of a guardian ad litem, which is good because then, the petitioners, the parents don't have to pay for that attorney. So that can certainly escalate the cost. But if there's any kind of dispute where, divorced parents, one doesn't want the other, they're going to put in a GAL right away to evaluate it because, these are important decisions and the judges really want to know what's going on behind the scenes.
Yeah, the judge has a pretty significant role
Yes.
in making that decision. I don't think people always realize what's really happening in that process. Yeah.
It's a lot of responsibility, and they want to make the decision correctly. And, they really have a duty to that individual to make sure that the right person is appointed. And then you can end up having a trial. But, I've done guardianship for a long time. I've only had one case over all the years that even went to a trial. And that was not a young adult. That was a elderly lady who she did not want a guardian, and she really needed one. But you bring in trial counsel to handle that. But for the people on this webinar, that's not going to be what you're dealing with at all.
Yeah. So what does the court require from the parents? What kind of paperwork do they have to gather?
So there's a petition that's filed with the court where you ask the court to adjudicate your child or sibling or whatever the case might be, a disabled person, and ask to be appointed the guardian. The most important part of this really is what we call the report of physician. So this is paperwork that is signed by the individual's doctor, whereby they make a conclusion that the person with a disability does not have the capacity to manage their personal and financial affairs. It has to be an MD, not a psychologist, even though a lot of times they have a lot of really good information, but the MD has to sign the paperwork. And then, if the physician concludes that this individual can't manage their personal affairs, can't manage their financial affairs, and there's no objection, that's sufficient evidence. We don't need to have a trial. We don't need to submit IEPs that were prepared. We don't need all of that. We try to pretty much give the court as little as possible to get the decision we want, because there's no reason to put all that information into a public court record unless it was required.
That's interesting. Okay, so do the parents and the family member with the disability need to go to court?
Yes, if you want to be appointed a guardian, you've got to show up and look the judge in the eye and swear that you will do a good job and that you are qualified to serve. So absolutely. It is not necessary for the person with the disability to appear. However, if they do not appear, the judge will appoint a GAL. So we always recommend that the person with a disability appears, because the judge likes to look them in the eye and see, is anybody objecting? Is anybody complaining? And then they will waive the appointment of the GAL. So you have every incentive to be there in court so the judge can see what's going on. You know, once the guardianship is set up, people don't really need to come back to court. But at that initial appointment, the judge wants to, you know, make sure that this is an appropriate appointment and that you are qualified to serve. You, in order to serve as guardian, you can't be convicted of a felony. You have to be over age 18. You can't be adjudicated disabled yourself. So they go through those questions to make sure that you're qualified and able to serve.
I have a funny story. The parents went with their son, and the judge asked the son if he wanted their parents to be their guardian or something. And he had some choice words to the judge, and the judge realized based upon that response that yes, he did need a guardian.
He did, yeah. They've seen everything. So
yeah.
Sometimes
parents still laugh about that with me.
Yeah, right. Exactly. So it's guardianship court. It's good. The attorneys are good. You know, it's every time I've ever done it, those young adult children they're treated very respectfully. And, you know, if they have anything to say, the judge will listen to them. And if they don't have anything to say, that's fine too. So
we've kind of covered this a little bit, but responsibilities. So the responsibilities of a guardian are very different than that of an agent or that of a supporter. Could you just comment about that a little bit?
Sure. I mean, the guardian has 100% authority, right? I mean, they have ultimate responsibility, and they also have responsibility to the court, because when you're appointed guardian by a court, you sign an oath, that's filed with the court saying that you are going to fulfill your duties, that you're going to be responsible. And so you're acting essentially as an officer of the court and under the authority of the court. So you're supervised, and that's all meant, of course, to protect the well-being of the individual. When you're acting as a supporter under the supportive decision-making, you are not making any decisions, right, on behalf of the person with the disability. You are, following up, you're getting information, you're getting paperwork, you're discussing these matters with the individual. And then you also have the ability to advocate on their behalf once a decision has been made. And then if you're acting under a power of attorney, you can act under a power of attorney if the person with a disability, essentially directs you to, but usually that means that the principal does not have capacity. There's been a turn for the worse, or something has gone wrong. If you're acting as an agent, you want to act in their best interest, according to the authority that you've been given. You don't want to act outside the scope of your authority, and you may be holding off trying to ensure that the individual is making as much of those decisions as possible. So they're different roles.
I had a really interesting case we talked about in a meeting today with some attorneys who were teaching us about a case that it really existed. And there was a older woman who had some disabilities who had a guardian appointed in her documents, but the person hadn't really acted. And all of a sudden it was this niece that was acting. But other people felt that that person, as the power of attorney, was not acting appropriately. So the other people brought it to court and said, this person is not acting. So it's a serious job and you have to do the right thing. And other people can, somebody else hired an attorney to prove that person was acting was not acting in the best interest of the principal.
That's very common litigation where an agent under a power of attorney has been appointed, yet they are acting improperly or they are failing to act, whatever the case might be. And then sometimes the sibling, somebody else is saying, we've got to get them off of there. I mean, it's difficult. These are family members, going to court and suing, but they go to court and they request that the powers of attorney are suspended and request that they're appointed a temporary guardian. And the court is definitely going to appoint a guardian ad litem to try to unwind what is going on. But that's not unusual. You have an agent who just won't act. They can't be bothered, or they're suspected of stealing money or whatever the case might be. So that's a little outside the scope of what I do, but I'm very familiar with those situations.
Yeah. It's just, I wanted to express that it's a serious job.
Yes.
And having a conversation in a family, when you take on those responsibilities, it's nice to have a family meeting to say, okay, I'm picking people within our family unit to have certain responsibilities for me. And it's a good conversation to have. You can still, but you can always change those people, you can always change docs. Okay.
You don't want to be appointed and fail to act. If you don't want to act, you need to sign a resignation and get off of there, but don't do nothing. You've got to act once you're appointed.
Yeah. So when you're thinking about guardians, what should we be thinking about if we're thinking about a particular person? And should they be my child's guardian, or should I just be power of attorney? Or how do I think about this?
Well, I think for most of the young adults, right, they're going to be looking at their parents to step in that role. So, but then when the parent is thinking about who's going to be the guardian, in the future, that's a little bit of a different situation. In all of these roles, my experience is that it's a certain personality type. People who are conscientious, reliable. They're the kind of people who make lists, right? They have a list and they like to check things off the list. So those kinds of, people who will follow through, those kind of personality traits are people who can very effectively serve in these roles. They have a lot of success in that. And family members can be appropriate, and then sometimes they're not, right? I think you have to do a really honest look at, is this somebody who can set boundaries? Can they say no when it's appropriate? Are they going to have the emotional energy to take on this role? Because, when people are raising their own families, to step in and be the guardian for somebody else or the power of attorney, realistically, maybe their schedule is really tight and they can't do it. So I think and some people are very good with financial decision making, and other people are good with the healthcare, but other people don't want to step into that role and have to make those kinds of decisions. So just because somebody's the oldest doesn't mean they're the best person to be appointed.
Right.
Maybe that'll be a takeaway rule. Often they are, but not always.
We did a session a couple of months ago with guardians, actual guardians, or people who were going to be appointed, or people who thought they might be appointed. And we had different ages. So we had somebody who was 60 who was the guardian for his brother. And then we had somebody else who were 50s, and they weren't sure if they were going to be appointed because the parents hadn't talked to them. Then we got someone who was a family, and there were 4 children, and 2 of the children had disabilities, and the other 2 were going to be future guardians. And then we had someone who was just stepping into guardian. It was all these different, and then really young people who their parents slightly talked to them about it, but they didn't know much about it. So they were all hearing how everybody thought about the future responsibility and the current responsibility. And all of them all of them had volunteered to do that when they were asked. But it was a really interesting conversation about what's your role and what's your responsibility, and what if you're afraid to do it, what if you can't do it. It was really interesting. And there's also the conversation as you're giving these responsibilities, and there's many children, who do you pick? And so that insight of, I like that one about the lists. If it was about lists, I'd be everybody's guardian, I think. I have lists on everything. But some of those skill sets are important to recognize. It was good. I like
that conscientious, reliable list maker person. I find nurses and teachers are good. Teachers are probably they're my preferred. Anyone who's a teacher, they're good guardians.
So now we're going to talk about co-guardians. And are there how do you do co-guardians, and are they ands or ors? And then what about co-agents and co-supporters?
So for guardians, it's yes, you can have co-guardians. The most common scenario is where you have mom and dad appointed as co-guardians, and it's really an and situation. Have you run into the or? I think I've run into that like once, but under the statute, if you're appointed, right? If you're appointed, it's an and decision making. But what happens is sometimes places will let one act independently of the other. Others require both signatures. So it usually seems to work okay. I think it's more with the finances. If you have co-guardians on the finances, they're pretty strict about having both be involved at all the times. Judges, I think, prefer not to name co-guardians unless it's the parents. They would prefer to have one because they don't want to adjudicate disputes between co-guardians. So they prefer one unless it's the parents. But they'll consider the facts in the moment, but I think they do prefer one if possible. Now, co-agents under the power of attorney, Illinois law does not allow you to nominate co-agents. So it's one person only, one for healthcare, one for finances and property. And if you look on the document, it specifically says you cannot name co-agents. And I think it's the idea of we've got to have a decision. And if we have two and then they're in disagreement, we're back where we started, which is where we can't get a decision made. And then the co-supporters, I don't see any restriction on that at all because it's a very different type of dynamic. I think you could have from what I can tell, looking through this statute, I think you can nominate multiple. I mean, if you're lucky enough, right? If you're lucky enough to have a team of people who can all help you in various roles, I think that's great. So
that fits in with our dream team well.
Yeah, exactly. I mean, the more people you can have who are involved and advocated and take an interest in your life and what's happening, I think that's good. But I think there's also very good reasons why there's limitations on the co-agents. Ultimately, somebody's got to take responsibility, has to make a decision, and the courts don't want to spend their time adjudicating disputes between co-agents. But again, they appoint mom and dad.
Is there any special training to be a guardian? Because that sounds like that sounds like the job that has the most things you ought to know.
Yeah, a couple years ago, the Guardianship Advocacy Commission, Illinois Guardianship and Advocacy Commission, they have implemented online training for guardians, and judges sometimes waive it if it's the parents. And I think the parents should do the training as well, but they will kind of waive it for the parents. But anybody who's a non-parent, they're going to require in the court order, it will say you have to complete this training online within a year of your appointment. And then there's a certificate that is filed with the court. So when we have guardianships where the new guardian is required to do the training, we send them the link for the training right away. And we say, you have a year, but let's do this in the next 2 weeks and get this over with and send us the certificate so we can file it with the court. So any of you can go and find this online. So if you Google, I don't think we have a link there, but if you go there, you can find it. And it's a series of slides. It's actually quite a good presentation. So I think there's like 75 slides, and then you have questions, every 5 slides that you have to answer true or false or correct or so forth. And then if you pass everything, you get a certificate and it's filed. So I think it's really well done. And I think
is there a cost to take this training?
No.
So anybody could go.
Anybody can do it. I did the training because I wanted to see what it was about, but to get the certificate, you have to enter a case number because then the certificate shows the case number. So I didn't offer, I didn't include that, even though I have lots of cases because I'm not a guardian. And so, but it's quite good. I thought it was good.
Good.
Kirsten, we just put the link to the guardianship training page in the chat.
Oh, great. Thank you. Yeah, it's right there. So once somebody's appointed a guardian, there's an annual, at least in most of the counties, there's an annual report on the ward that needs to be filed with the court. For guardian of the person, like I said, it's usually yearly. Sometimes it's every 3 years. Again, I think DuPage is changing to every 2. But that's a 1 or 2 page document where you just report, the ward still resides in this county and they've gone to see the doctor and I visited like to make sure everything is okay. I always tell people when they're filling out these reports, use all your words, fill in all the blanks, use lots of words, and then it's just filed with the court. A lot of our clients will file the report of the person on their own. You set up an electronic account. I'm not sure if they charge when we file it. It does cost like a couple dollars or something, but I'm not sure if when the guardian does it on their own, if there's a charge, but you file that. It used to be you'd take it to the court, but now a lot of it's electronic filing. So if there's an estate that's involved, it's a much more involved process because you have a duty to report to the court on all expenditures from the estate. And so usually an attorney is involved in that. There's formal accountings that could be presented to the court. That's more of a project. So you want to make sure you understand what your responsibilities will be every year. Now, for powers of attorney, that's a little bit different. I mean, if you're acting as an agent, you want to make sure that you have a record of what you've done, right? You don't have a reporting requirement to any court, but you have to envision if I'm doing something and then if I end up in court, I could be held to account to the court for the action that I took. So there's no yearly requirement, but whenever you're acting in a fiduciary capacity, you need to be prepared to be able to document to a court if there's a problem. That would be incredibly rare, right? If it's a parent serving for their young adult child, that would ever happen. But in scenarios where if you're acting as a guardian or power of attorney for a parent, sometimes there's a sibling who doesn't trust what's going on and they want to go to court like we talked about previously. So you always have to envision if I have to present this to a court, and that's why a lot of people who are acting as power of attorney, they retain attorneys to guide them to make sure that, they don't trip up and, they don't accidentally end up in trouble. Supporters, there is some accountability there that third parties, if they felt like a supporter was taking an advantage of a person with a disability, there is a court remedy. I was going through the statute, so they're able to go to court and get a temporary guardian appointed. So there is, and that's good that there's some accountability there, but there's no reporting requirement in the same way if a full guardianship is open and implemented.
Yeah. I've been power of attorney for family members for financial and care. I just made it a habit of setting up a little QuickBooks system and documented what I did. So if anybody came along and said, well, how did you do that? Where'd you spend their money? How'd you take care of them? I could just put a report out and show them and they're like, oh, okay. And I volunteered it.
Good job.
Yeah. I said, okay, here it is.
Here it is. Yes.
Everybody wants to sit down and see what I'm doing. It feels, anybody else wants a job, step up, sometimes.
Yeah. Yeah. There's no secrets, you can always go to court in these fiduciary roles and be, called to account. So you gotta be careful.
So, okay. So now let's say I'm the guardian for my child. And I am going to have to pass that job along when I pass away because someone has to have it. What happens? How do I do that?
So you're able in your will to appoint a successor guardian. So you can designate that in your documents. But the thing is, nothing is automatic, right? So guardians serve via court appointment. So you can have a successor guardian named in your will, but at that time, that individual who's nominated would have to go to court, file a petition, report the death, and so forth. There is a process whereby you can appoint what's called a standby guardian, where it's like you do the court proceeding in advance. The standby is there, they can't serve, they don't have authority now, but upon the guardian's death or disability, then they can step up. I have just found it it's pretty rare that we've done that because, well, for various reasons, I'll just leave it at that, but it's pretty rare to do that. But in some cases that's appropriate. It's just once you get that person in there, you can't change it. And what if the situation changes and so forth? So,
if it's kids, let's say mom is sick, dad's gone, mom is sick, and she's the guardian.
It might be time for her to resign or have one of the adult siblings step up and deal with it proactively rather than dealing. We try to avoid emergencies. That's our goal. We can't always do it, but if mom's not doing well, dad's passed away, let's think about what the next step is going to be now rather than waiting for the inevitable.
Right. And you don't want a gap either between death. And so you got to think about all those things. But I just want to remind people, you're not appointing whoever you put in there still has to pass the courts.
Yes.
Right. And so you're really nominating those people. They still have to meet court approval. Yeah. And you can't force people. This is a really question I have. So let's say in my will, I name my sister to be my son's guardian, and I pass away and she decides, she could decide she doesn't want it. And I would have appointed, maybe I said my sister, and if my sister can't or won't do it, then I want my brother. Okay. So let's say my sister takes the job. Now she's guardian. She goes to court and she petitions to become the guardian. She becomes his guardian. If she dies, does the person I put in my will, the second person, step up, or does she have to change her will and nominate a new person? They probably would, because by that point, I mean, it's the same thing. They're going to have to go to court. And so they would show, I'm nominated next and so forth. But I think that original designation, but there's only so many interested persons, right? Right. But at that point, if mom's gone and the daughter has passed away, and then there's the other brother, he's really the only one who's going to have standing to really even go to court and resolve the issue regardless. So, but if my sister had nominated somebody else. Yeah. Well, that's interesting. Yeah, there could be a dispute. I mean, if she nominated somebody else and then the brother wanted to serve, that's where you end up with the guardian ad litem, right? Yeah. I mean, they could certainly name somebody. Yes. Yeah. So they could. Okay. Just I'm always curious about, as I have clients who are getting older and older, they're starting to think about that. And then the future guardians are starting to say, well, something I should be doing then, because there's nobody else to have the job after me. I should probably nominate somebody in my will. Yeah. You're right. You are right. They should be thinking about that, and they should be putting that in their documents. Yeah. So what about the powers of attorney and supporters? How does that job get passed along? Well, in a power of attorney, remember you're alive, right? And you've named an agent. And then if that agent is unable or unwilling to act, then the successor agent who you've named in that original document would step up. Okay. Yeah, exactly. And you have the ability to re-sign your power of attorney and name new agents if you'd like to do that, or revoke. Right. Got it. Okay. And the supporters, it's the same kind of thing. You'd have to find somebody else to do that role. I think you just find somebody else. I don't really, as I look through this, I don't see supporters as something you designate or anything. It seems to me like it's an agreement that you make in the moment, and then if it doesn't serve you anymore, you could revoke it, and then you have a new supporter. But I don't think it's almost like hiring a contractor. Yeah, exactly. It's like hiring. You gotta find a new plumber. Yeah, I don't see supporters being designated in documents or things like that. Right. Good. So, somebody's become a guardian. Can we terminate guardianship if we feel it's no longer needed? Yes. Guardianship is not permanent in the sense, well, it is permanent, but you can always go to court and terminate it if it's inappropriate. In fact, there's a duty for the guardian to report to the court if the ward no longer wants a guardian or needs a guardian. So the last thing we want to see is a guardianship continuing when it's no longer appropriate. So I have terminated several guardianships, but you've got to have evidence, right? If you go to court, you want to be able to provide documentation by a physician saying, this has changed, and they have the ability to do that. So you've got to be able to make your case. And the judges
if it's appropriate to terminate, I mean, they're not going to continue it, but you always have to present evidence to the court to support that.
What if somebody's a guardian and they say, I just can't do this anymore? Can they
Well,
resign and then
they would
somebody
have to be
else-
discharged by the court. So everything is pursuant to court order. So the guardian would have to petition the court, say that I want to be, I want to resign or be discharged is the correct terminology, be discharged as guardian. They would present a final account to the court to say, this is what I did. But no, a guardian, they can't be forced to serve. If they want to be discharged for whatever reason, the court is going to allow them to do that. But they can't they can't resign. Like in a trust, you can sign resignation documents, but a guardianship, you have to get a court order.
That's very court ordered. And the other agents and supporters are just the person signing new documents.
They would, they'd sign new documents, and agents can always resign, and a supporter or the person with a disability can terminate that. That's a more fluid situation.
Well, we talked about this a bit. Can someone with full guardianship
in Illinois, they can vote.
Yeah. And drive could be requested.
Yeah. Driving. Yeah.
So, we covered a lot of stuff. That was fun.
That was a lot.
Yeah. So, Mary, are there questions for us?
We do have a couple of questions. Yes, we do.
Okay.
When a guardian dies and there's no successor guardian in place, who's legally responsible until a guardian is appointed if the person needs medical attention? Who makes the decision?
Well, if there's no guardian appointed, I mean, there's nobody to make the decision. I mean, in those situations, you need to move pretty quickly. And if it looks like nobody in the family is going to step up, then the office of the state guardian or the county guardian would step in. I don't get involved in those cases very often. That doesn't happen, but that's what would happen. But you're right. If there's a gap in the appointment and nobody's in that role, there is nobody to make a decision. So we want to avoid that as much as possible.
But the state does have a
Yes.
process to step in.
Yes.
And that's not what you want.
Takes time. Yeah, but that takes time too. It's not, like we'd have to go to court and then they'd have to petition and then they'd have to review and see, is this appropriate? Can we take it? Nothing is instantaneous because it's all a court proceeding. So that's why we want to plan ahead. We don't want mom or dad in that role and their health is deteriorating and we don't have a let's have a plan before, we're in an emergency situation.
What happens if you can't afford the guardian ad litem?
Well, if you can't afford the guardian, well, you want to set things up right so that you don't have a guardian ad litem appointed, right?
Mhm.
And that's within your control. If a guardian ad litem is appointed and there's litigation, there's going to be costs associated with that. I don't know if there's a way to waive that, or perhaps the attorney in certain cases may decide to waive their fee, that kind of thing. But guardian ad litems, when they're appointed, are entitled to fees, but I can imagine some would waive them in certain extraordinary cases.
Okay. If you have legal guardianship of a minor through whatever circumstances, do you have to file again when they turn 18?
Yes. So if they need a guardian as an adult, yes, you have to adjudicate and have a finding that they are a disabled person. So all minors need guardians, right? All minors need guardians if they don't have their natural parents serving in that role. But that doesn't mean they're a disabled person. So it just means that they're a minor. But yeah, at 18, you're going to have to file and have a finding of disability.
Well, thank you. Well, unfortunately, our time has run out, so we'll have to answer any additional questions individually. Marianne, thank you. Kirsten, thank you for being with us this evening and sharing your knowledge. This presentation has been recorded for future reference and will be posted on the ARC's website. We'll be sending you a link, and the ARC will be sending you a link via email once the video has been uploaded. Thank you again for your participation. If you have any questions or would like more information, please feel free to contact us at any time. We hope you have a wonderful evening.
And I'd like to again thank Kristen so much, Kristen, for participating.
It was my pleasure. Thank you.
Yeah, it was really fun. And American Bank and Trust, again, for sponsoring the event. I don't know if Trista was on to say a few words. Mary, do you know?
She is not.
Okay, so American Bank and Trust was gave us the courtesy of sponsoring this for the Arc of Quad Cities. And thank you, Arc of Quad Cities, and all of your team for inviting us to participate. So thank you again. We truly enjoyed it. And if you have questions, again, here is Kirsten's information. If you need an attorney to help you, she is excellent. So have a great evening, and we look forward to next session, which is going to be planning for the future. Okay. Good night.